let's dive into this because this is something that, honestly, folks, near and dear to my heart. Let me tell you why. I'm a born and raised New Yorker. I was born in New York City, grew up there, and other than my time in the CIA and my time in college, I have been a New York resident for basically my entire life. And one of the great frustrations of living in not just New York City, but New York State is that it is, along with a handful of other states, Maryland, Massachusetts, California, New Jersey. There are 6 that are cited in the Supreme Court decision, but along Hawaii, along with a handful of other states, effectively Second Amendment no-go zones, as much as they can be. You can own a shotgun, although you have to get a permit usually. Depends on the state. But overall, they have in place a regime that's meant to prevent you from actually enjoying your right to bear arms. Key phrase here, as we all know, folks, to keep and bear arms. That first part, the keeping of the arms, was dealt with pretty well in D.C. v. Heller. Remember that case from some years ago? You had an individual licensed to have a gun for work, but who lived in the District of Columbia and could not even bring his firearm that he had at work all day home with him. So that's crazy, right? But that was the law, and they would arrest you. D.C. was vicious about enforcing even the most minor infractions of firearms law. Unless you're a gang member with a long history of drugs, then they're always looking. And this is the thing you have to remind yourself about the libs. If you're somebody who has guns and is actually a danger to society, they don't want to make an example of you. They want to go soft on you. This is what we've seen with the progressive prosecutors and criminal justice reform, as they call it. But if you're a guy who likes to go hunting on the weekends, but you cross from Virginia into D.C. with 2 shotgun shells in your pocket that are 20 gauge meant for pheasant, guess what? Too bad. You're on your own. They're going to lock you up. That's their attitude, right? Well, in this case, this New York State Rifle and Pistol Association v. Bruin. Bruin was the superintendent of the New York State Police. What we have here is the bear arms part of it, finally coming into Supreme Court focus. And by 6-3, the proper cause requirement for getting a handgun permit or firearm permit to have and carry a concealed pistol or revolver, the proper cause requirement is gone now. It is unconstitutional. Now, what this means in effect, remember, D.C. v. Heller said you got to be able to, if you're a law-abiding citizen and you meet some very basic thresholds, you've got to be able to buy a gun. You can't just say you're not allowed to have a gun, period, because the Second Amendment. Well, now it's, can you get a concealed carry permit? Can you actually carry your weapon with you? And I know there's going to be the whole distinction between concealed carry and open carry and all this, but just to be able to carry in any capacity in these states was not allowed unless you were special, unless you could demonstrate a special need that's different from just people in general. And 6-3 decision here. Roberts did join the majority. So he may be a wimp, but he's not a lunatic. 6-3 decision took a sledgehammer to the anti-gun regime of so many of these states, or I should say the anti-bearing arms regime, right? Because you're allowed to own in New York, you're allowed to own a firearm in California, but can you carry it anywhere? Can you get a concealed carry permit? Now, in the state of New York, as I said, this is near and dear to me because I have not been able to, as an adult, I have not been able to enjoy Second Amendment rights in my home state. And it's obscene. And one of my favorite parts of this decision, right, one of my favorite parts of the way they dismantle, I mean, the libs here, the libs, Breyer, Sotomayor, Kagan, just pathetic stuff in their dissent, honestly. Oh, but there's so much gun violence. Wait, but there's so much gun violence. You guys are banning guns in these states in every way you can, but there's still so much violence. Almost like the only people who are going to have guns in a no-gun regime state like New York or California are the bad guys. Oh, that is what happens. That is what happens. New York bans and has for over 100 years. I've known about the Sullivan Law passed in 1911. By the way, I rarely would say this to you. If you are a Second Amendment enthusiast, though, reading this whole decision, just because of the history that it goes into is fascinating. The history of weapons and concealed carry and the Old West and even goes back in the medieval period, goes back to English common law, 17th century, 18th century. It's fascinating history, of course, written by the constitutionalists, the conservatives in the court, in their 6-3 slapdown of this unconstitutional absurdity of you're not allowed. A law-abiding American in these states was not allowed to get a pistol to carry concealed for protection unless they were special, which basically meant unless you're connected, unless you know how to work the system. And that's why, honestly, you know who's getting concealed carry permits in New York City specifically? Celebrities, famous, important people, powerful people. And they usually often had armed security on top of all that, too. But, they wanted to feel like they could defend themselves. Well, that's not the way this is supposed to be. But the history that it goes through in this case is fascinating. Just from a perspective, if you want to know the history of self-defense law as it pertains to the carrying of arms, really interesting stuff. And then beyond that, they make the case very clearly that in a place like New York, because and there's so much that goes into this. There's a 2-step test they discuss. I mean, the legality of it is fascinating. What really, though, it came down to for so many decades now, and even in a post-Heller world, this is what the courts, numerous appeals courts, had upheld this standard, which was essentially, yeah, but if Democrat states think it's really important to not let you carry guns, that overrides your Second Amendment right to carry. Because we say so, is effectively because we're neurotic libs, and the notion of people who are law-abiding citizens being able to defend themselves, having a chance to defend themselves, is something that upset people who live in, the fanciest parts of Boston and the Upper West Side of Manhattan and Santa Monica and Beverly Hills out in Los Angeles. It upsets people who live in the very safe neighborhoods. Oh my gosh, you mean my neighbor who's totally law-abiding and trustworthy in every aspect of his life or her life might be able to carry a concealed weapon? That's terrifying. I want only the gang members, the murderers, the assaulters, etc. to be able to carry. Apparently, that's what the libs have been suggesting this whole time. Because as it states in this, and this is a total smackdown. And this is home run from the perspective of the Second Amendment. This decision, I'm saying. This was really as good as you could have hoped this case would be. And by the way, we may be getting Roe overturned tomorrow. So this is one of the biggest weeks, possibly, the Supreme Court has had in at least a decade. I mean, this is massive if this continues. Assuming Roe comes down tomorrow it's not actually Roe, but it could overturn Roe. So here we are now looking at a major win for the Second Amendment. And as I was telling you, and we could go into more of the tests and everything else, but the most important takeaway is that Democrats want to be in a position to tell you that you cannot, through their state legislatures or the mayor's office or the police commissioner or whomever, you're not allowed to defend yourself with a concealed pistol. And, of course, there are 43 states, I believe, that already have 43 states that already have some form of you may get, right? Most states have already understood this, but there are 6, and they happen to be some of the biggest. They're the biggest population state, California, and a couple of other mega population states, New York, New Jersey, have been terrible on this issue for a long time. So now we're through that. You will be able to. They're going to have to pass laws in the state legislature. I'm sure they're going to make it annoying. They're going to make it expensive. But isn't it fascinating that at the same time that some Republican senators are bending the knee on red flag laws and mental health funding that they think is going to stop shootings or whatever they believe will be accomplished with this. Some expansion of background check to go into juvenile records. The same week that Republicans bent the knee, the Supreme Court actually dealt a devastating blow to the gun grabbers. And it's about more than, and I'll come back and talk to you about this in a second, there's more at stake here than just your neurotic lib neighbor or libs like Pelosi and Schumer, who have been defended by men paid by the state with guns their entire adult lives. It's not just that it makes them uncomfortable that you just a person, an American, not an important person, just a person, might be able to defend yourself. There's also some fascinating lessons from that history that is laid out in this New York State Rifle and Pistol Association v. Bruin ruling. And I want to get to that because it actually goes to the heart of the Second Amendment, and it goes to, I think, some of the very important lessons we have learned when it comes to the state and its overreach and tyranny in recent years. So we'll dive into some of that when we come back. And I have so much more to talk to you about, including a case of how wrong the criminal justice reform mindset can go in New York City and other places.
But I will say we are not powerless in this situation. We're not going to cede our rights that easily, despite the best efforts of the politicized Supreme Court of the United States of America. The Supreme Court has now decided, with this far-reaching decision, that the two-step standard that had been in place since Heller versus McDonald, no longer can we strike the balance. Only if a firearm regulation is consistent with this nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Shocking. Absolutely shocking that they have taken away our right to have reasonable restrictions. We can have restrictions on speech. You can't yell fire in a crowded theater, but somehow there's no restrictions allowed on the Second Amendment.
Welcome back to Clay and Buck. This is Buck in solo today. Clay's out on vacation. And that was the governor of New York, Hochul, whom no one actually voted for or elected or anything like that. She just got appointed, and then, Cuomo was grabbing too many of his subordinates, and so he's out. Not because he forced grandma with COVID back into the nursing home and had the most catastrophic results of any nursing home communities in the whole country. That's not why the libs got rid of him. But Hochul, listening to her constitutional analysis or her sense of firearms law, honestly, she should probably just not speak about this at all. I would rather hear Joy Behar make completely inane, at least her statements will be amusingly stupid. Hochul just says really dumb things, has no idea what she's talking about. The notion that these are reasonable restrictions, it's not reasonable. It's not reasonable to say you're a law-abiding citizen, you have a Second Amendment right, but I'm not convinced if I'm the, sheriff for your county. I'm not convinced you need a gun, so you don't get one. Oh, but somebody else, I think they need one, so they get one. This is the definition of capricious. This is the definition of the rule of men over the rule of law or instead of the rule of law. And we all know it. Look, all you have to see is at the very top of the, and just for anyone joining us, huge decision that came down today, 6-3, where the rules around giving someone a carry permit for a firearm in states that require a need to be proven, that is unconstitutional. Huge implications for New York, California, and a handful of other states. In the dissent by Breyer, Sotomayor, and Kagan, this is the first line of the dissent. In 2020, 45,222 Americans were killed by firearms. Oh, what does that have to do with the constitutionality of law-abiding citizens carrying a firearm? I mean, just think about this. Really, their dissent comes down to guns are gross and scary, and bad people like to lawfully have them. Notice the fascinating separation here. Democrats can always find ways to sympathize with criminals who use guns to hurt people. Oh, we don't want to send them to prison for too long. Just look at the statistics. I'm not making this up. The data proves my point. Look at what they're doing in New York. Look at what they're doing in Philadelphia. Look at what they're doing in L.A. and San Francisco. Prohibited possessor, previous felons in possession of firearms, dismissed, case dismissed. Go look up the case of Mark Wittishek in Washington, D.C. I remember I interviewed him a long time ago. The guy was a sport hunter, wasn't even about self-defense. Had a defunct shotgun shell on him, and the District of Columbia wanted to send him to prison for it. That's who they want to make an example of.
The Supreme Court, in a 6-3 decision here, striking down this New York gun law. This is an opinion that was written by Justice Clarence Thomas, and this says that that particular requirement about getting a license to carry a handgun, a concealed handgun in public, that it violates the 14th Amendment. The conservative majority here, guys, is really going back to this idea that the Second Amendment has really become a second-class right. This is something that we've heard Justice Thomas say in opinions. We've heard him say it in public. Justice Alito as well, saying that they believe the Second Amendment has become a second-class right. And now in this particular opinion, they're striking down this New York gun law.
Welcome back to Clay and Buck. This is Buck in solo for the day. And it has become, the Second Amendment has become a second-class right within the Bill of Rights. And that needs to change. And today's 6-3 ruling, and it's an excellent ruling, is certainly a step in the right direction. The more you think about this, the more you dive into the arguments, the text, the history, you find that it's stunning, really, that the libs were able to get away with this as long as they did. I mean, what purpose does it serve? Just think about it in this context. And I know we have so many listeners in New York and California specifically. I'm a New Yorker. They wouldn't let me. I was trained by the CIA. I was in the NYPD for a short period of time, about 18 months, as an intelligence analyst. But, I mean, I had federal government training with firearms. I am a law-abiding citizen. Everybody around me would be made safer, in my opinion, by my legal carrying of a gun. Would not let me have one. Would not. It didn't matter if I applied, said, hey, here I am. I'll do the fingerprinting. I'll do the course. Whatever. Just tell me what I have to do to get one. No. Prove that you're special. Prove that you're important was the law in New York, particularly in New York City, even worse in New York City than in New York State. This is obviously not the way the rule of law is supposed to work. But libs are terrified of law-abiding gun owners. That's the fascinating part. Criminals, people who misuse guns, liberals have a soft spot for. But people who want to carry and defend themselves and their community and go shooting at the range on the weekends, perhaps, that's scary to libs. Ooh, guns make big bang noises, and I hate it. Keep it away. I don't want the scary gun noise. So that's reflected, by the way, in the dissent here. But something is, I do love history, and I want to get into the criminal component of this and how it ties into what we're seeing nationally in just a moment. But I mentioned to you that there was some fascinating historical discussion in this Supreme Court case that came down today in New York Rifle and Pistol Association v. Bruin. And I just want to read to you. This is from the opinion written by Justice Thomas, who is, I've said this before, if I can come up with a better, more specific phrase, but he is a national treasure. He really is. Justice Thomas is just an amazing man who should be so much more. I mean, he's celebrated by conservatives. He should be so much more celebrated nationally than he is, just for being brilliant, for having an incredible life story. But I digress. When we look to the latter half of the 17th century, this decision says, respondent's case only weakens. As in Heller, we consider this history between the Stuart Restoration in 1660 and the Glorious Revolution in 1688 to be particularly instructive. During that time, the Stuart king, Charles II, and James II ramped up efforts to disarm their political opponents, an experience that caused Englishmen to be jealous of their arms. I thought there's other examples like this, but this is the key point, friends. When you look at the history of these efforts to disarm the law-abiding, whether it's in England, whether it's in the medieval period, or it's in the revolutionary period in America, you look at these efforts to disarm, it's always a means of the powerful asserting their control. Because they want to be able to do whatever they want to do. They don't want anyone to be able to say, no, you're a tyrant. No, you've gone too far, and I can do something about it. And this really goes to the heart of the Second Amendment. When you read through the history, it's fascinating. Those with the guns or the swords and the daggers and the halberds and, those with those weapons, they don't want others to be able to meet them with steel and gunpowder. They want to be the ones that get to call all the shots. They say, you know what, we're just going to, no, you are not important. You don't get, and you could look at all throughout history, different times where just the carrying of a sword, unless you were connected to the nobility, was something that could get you even executed, right? But then there are other times where there was an expectation that all gentlemen would be carrying. There are cultures, actually, where you have to carry a working blade. Cultures were carrying a knife for utility and for the protection of oneself and perhaps even one's faith or one's state. That was expected. The libs, ultimately, there's the criminal justice component of this and the self-protection, but then there's also the defense against tyranny aspect. And the left in this country, the anti-gun Democrat Party, which now effectively is all the Democrat Party. There are some who will still pretend here and there to win some votes that they're pro-Second Amendment. But the Democrat Party has become the anti-gun party because they're authoritarians. You've seen this over the course of COVID. You see this in your day-to-day lives. They want to control your speech. They want to control your property. They want to control every aspect of your life. They want to brainwash your children into gender identity theory. They want full and total control. And even if they may not have the eloquence and the constitutional understanding, which they certainly don't, to put it in these terms, they do understand at some level that the individual ownership by citizens of this country of firearms is a personal act of rebellion against authoritarianism. Or at least the possibility, waiting in the wings, waiting on the sidelines, to be that act of rebellion should it be called upon. And they hate that. They hate that because they know somewhere deep down, hold on a second, we can't just force them to do anything we want if we have full and total control of the apparatus. We can't just start pulling people out of their homes and arresting them in front of their families because of climate denial. What do you mean? That would be a problem for us? Ultimately, the true believers on the left, the real center of the Democrat Party, finds that notion of an armed populace unacceptable. Unacceptable to them because they're always trying, they're progressing, you see. Yeah, they're always moving for the next thing, moving to the next issue. But their ultimate progression as progressives is to get to the utopia that is only possible when they are in total and complete control. And so long as we have an armed population in this country, that represents the final bulwark against that tyranny. And they know it. So they hate it. And they also like all the virtue signaling, of course, from if we could only pass more gun laws, we would stop all the gun violence out there. It's not true, but people say that and they feel proud and brave and smart. If only we pass this gun law, no matter how many times they fail, it feels good for them to say it. It feels good for the left to shout this out. So they will keep doing it. They won't look at the data. It doesn't matter to them. They want you disarmed and double masked. That's the point. That's how they see this. And if we allow them, that's where we'll go. But today's Supreme Court decision, a huge victory, a huge move in the right direction. I gave a shout out to Justice Thomas, who a lot of us know he's amazing, but deserves even more praise than he gets from those of us who are fans of his jurisprudence, his sharp mind, and his courage. In this decision, he wrote, "A short prologue is in order. Even before the Civil War commenced in 1861, this court indirectly affirmed the importance of the right to keep and bear arms in public. Writing for the court in Dred Scott v. Sanford," of course, one of the worst decisions in the history of the Supreme Court, Chief Justice Taney offered what he thought was a parade of horribles that would result from recognizing that free blacks were citizens of the United States. Again, this is a quote from the decision. "If blacks were citizens," Taney fretted, "they would be entitled to the privileges and immunities of citizens, including the right to keep and carry arms wherever they went." Thus, even Chief Justice Taney recognized, albeit unenthusiastically in the case of blacks, that public carry was a component of the right to keep and bear arms, a right free blacks were often denied in antebellum America. And that's the end of the quote there. Just a reminder as well for everybody, It was the racist Democrat Party that worked so hard after the Civil War to make sure that that black citizens of this country were disarmed. It was the racist Democrat Party during Reconstruction and then leading all the way up into the era of the Ku Klux Klan that was doing everything it could to disarm our fellow Americans who were black. So there is as I said, a long history of disarming in the name of oppression that stretches back for hundreds of years, not even just in America, but hundreds of years, stretches back all throughout history. The people in charge want you to shut up and do what you're told. They get the guns, you get the orders. That's the way they've wanted it to be. Our founding fathers, and the reason for the Second Amendment, they realized, no, that's not going to work. We're not going to have a free society, a truly free society of individuals with real liberty unless we change that dynamic. So I think that's essential to take away from all this.